Good afternoon, guys. My name is Alena Shautsova. I'm an immigration attorney from New York. And today we're going to have our live about the most interesting immigration news and updates. We're going to discuss TPS for the new country, Cameroon. We're going to talk about asylum EID or work permits and what you need to know if you're going to be filing for a renewal. We're going to be talking about Stokes interview as well, Stokes interview practices. So if you're new here, welcome. Please make sure to like, share this video, subscribe to my channel if you would like to stay updated with regard to the most interesting immigration news in the United States. And say hello, let me know where you're watching from. And of course, save your questions, type them up rather in our chat, so I will be able to get back to them after my presentation and answer your questions. Thank you very much, guys, for joining. Thank you thank you, Lori. Thank you. Thank you, Armand. Thank you, Hamad. I'm very glad you all are following my updates. Thank you for your best wishes. I was very touched by all of your comments. Thank you, guys. And let's start. There's those of you who are joining just now, again, say hello. And I published the topic here. You can see it on the screen. We're going to start with the news, good news for a new country, Cameroon. Cameroon has been designated for temporary protected status, as you may be aware. And finally, now DHS is going to start accepting applications for TPS or temporary protected status for people from Cameroon, starting tomorrow, June 7th, 2022. It's extremely important that if you qualify, you apply for TPS if you are national of Cameroon. Why? Because it's going to give you very good protection from removal or deportation. You are eligible to apply even if you already have an order of removal. You're eligible to apply if you entered the United States without inspection, if your status expired, or even if you are in legal status. Some people think that if they are in legal status, let's say F1 or H1B, they do not need to apply for TPS. I assure you, you will regret it later. So please consult with an attorney if you think you are eligible and absolutely file. Some of you may think that they may not be eligible for various reasons, and that's okay. If you think that, you still have to check with an attorney what you need to do. In most cases, if USCIS challenges your eligibility, they're going to give you a notice. They're going to give you a notice for request for more evidence, or they will ask you to file for the waiver. It means that if you have even a small chance to benefit from TPS, please file for it. But of course, consult with an attorney prior to make sure that you're going to increase your chances of having TPS approved. TPS does not lead to a green card by itself, but it's going to give you an opportunity to travel, advance parole. It's going to give you work permit, just like it provides such an opportunity for people from Ukraine, for example, or other TPS designated countries. So absolutely make sure that you file for it. Remember also that even if you have dual citizenship, you may still be able to file for TPS and win it if you can show that you did not formally resettle in another country. It's extremely important to know that, so please take advantage of that opportunity. Another little topic I wanted to talk with you about is a topic of asylum work permits. Why? Well, because work permit is one of the most important things, important benefits that an immigrant would seek in the United States. And of course, with growing asylum backlog, sometimes you have to wait for your asylum hearing or asylum interview for years. Work permit is essential for you in the United States, right? And you may be aware that during the Trump administration, eligibility for the work permit was slightly challenged. Well, Trump administration stated that you would be disqualified from asylum-based work permits if you have certain violations or arrests in your record, and also if you cannot show that upon entering the United States, you immediately surrendered or presented yourself before the DHS authorities. Hence, you may know that Form I-765 was changed and additional questions were added to that form when you would try to file for the work permit. For example, you would see that certain questions were added regarding your arrests and for example, have you ever been arrested for and charged with any or convicted of any crime in any country? And that was not an unusual question, but after that there were questions, did you enter the United States lawfully, and so on and so forth. So now, because of the lawsuits that were filed and challenged Trump administration's decisions to disqualify certain asylum seekers from work permits, these extra questions, most of them, do not have to be answered anymore when you file to renew your work permit or you file initial work permit based on C8 or asylum pending category. You still have to answer question 30A. Have you ever been arrested for and or charged with and or convicted of any crime in any country? Just because an aggravated felony conviction would prevent you from receiving work permit based on asylum pending. But the rest of the questions regarding how you entered the United States, for example, don't have to be answered. I think it's a good information to know because it may be helpful, right? These questions that you see to my left, I guess, yes, to my left, don't have to be answered. Because before you would have to explain when you presented yourself before the authorities and how soon and country of claimed persecution and so on and so forth. So that makes your life a little bit easier, all right? So no longer need to face those questions, which is, I also believe, is a good news. So slowly but surely, the Biden administration is undoing the harm that was done by the Trump administration, even though not completely. We still have certain areas of law where strong improvements are needed, as you are aware yourself. We're still waiting for immigration reform, and many other aspects of immigration law needs to be changed, right? Very, very important. Now I'm going to move on to my third interesting point. I'm going to talk to you about the Stokes interview. Stokes interview is a very interesting topic. Why? Because many of you who are filing for adjustment of status based on marriage are probably worried about it. Interview is called Stokes when couples are separated at the time of the marriage-based adjustment of status interview and are questioned very thoroughly about all aspects of their lives. And the reason for it is for the officer to determine whether or not you are going to be accused of fraudulent marriage, So that's very, very important for you to be prepared for such an event. Yes. So if that happens, you're going to receive something like this, right? A notice that is going to mention that you're going to be called for a Stokes interview. And here where I wanted to provide you a little update. Interestingly enough, that at least in New York right now, you may receive such a notice calling the interview a Stokes interview even if this is your first interview for the marriage and not a subsequent interview. Why this is interesting? Well, I'm going to tell you why it's interesting. It's because you see what happens. Usually you receive a notice for the Stokes interview only if you failed your first interview. And then a significant amount of time is going to pass usually between the first interview and the second Stokes interview. This time will allow you to think about your actions and hire an attorney if you didn't have one. But recently, USCIS in New York started changing its practice. They sent you a notice, the first notice, that is going to be called Stokes interview, right? And however, most likely it's not going to be traditional Stokes interview where you guys are going to be separated. So don't be upset and don't freak out if the first notice for your marriage-based green card is going to be called Stokes. It's not necessarily that immigration will immediately separate you, no. But what's going to happen is that if the officer determines that the marriage may be fraudulent or done for immigration purposes, then you will be separated. It means that nowadays you have to be super duper prepared for your first interview already. Well, I hope you're always prepared, but just for those who think that somehow they do not need preparation, and you have to have an attorney with you. This will be my best advice to you. Why? Because for Stokes interview, you do have a right to bring an attorney with you to be represented. That's why USCIS started calling the first interview Stokes interview, so you're prepared. And in case you show up and don't have an attorney, you won't be able later to say, well, but I didn't have a lawyer and you didn't give me sufficient notice to hire one. They're going to say, we did give you a notice. It says Stokes, so you should have known better. Understand? So it's very, very important for you to know this. It's very important for you to be prepared for your marriage-based interview. And just a little tip, how to prepare for the Stokes interview. Well, number one, you review all the paperwork that you previously submitted. Paperwork, forms. If when filing a case, you did not submit evidence of real marriage, which is a big mistake. You have to submit evidence of real marriage at the time of the filing of the case. Make sure to bring that evidence with you to the interview. If you did submit evidence, very good, you did your homework. However, you have to bring updates as well, okay? You will going to accumulate additional evidence from the time that you submitted your paperwork until the time that you're called for the interview. So you have to collect all that and bring it with you to the interview. And lastly, you have to sit down with your spouse and practice. You have to practice and answer questions about your life out loud. So you will understand. Sometimes you'll be surprised how different the answers may be. You can ask your spouse, you can just practice. You can write yourself like 5 questions and write your answers and ask them your spouse, and you'll see, even you live together and you think you know each other, how different the answers may be. For example, about when was the last time you went out? He's going to remember, or she's going to remember 2 weeks ago event, and you're going to remember a 3 weeks ago event. Trust me, it's always like that you always are a little bit off in your answers. But of course, the majority of the information, if you do live together, you will know about each other. Just little things here and there that you need to practice. All right, so now if you guys have questions, I'll be happy to answer them. Let me see. We have a lot of questions today, which is very good. Hi, George. Hello, congrats. Thank you very much. Thank you, guys. Let me see. Hi, Lori. Can I change from pending asylee to EB3? The answer is maybe. It depends on your situation, when and how you entered the United States, when you filed for asylum, and if you're willing to fight for it. Because if you are watching my broadcast, you probably know that there is an exception to the rule that the person who's filing for adjustment of status based on employment sponsorship must be in lawful non-immigrant status. There is arguable exception for that for those who are asylum seekers and were able to file their asylum cases prior to the expiration of their lawful non-immigrant status that they received at the time of entry. And if this is your case, I suggest that you consult with an attorney and see if you are willing to fight for it, because USCIS may challenge this theory of the case, as they do sometimes. But attorneys report such a theory works for, let's say, Chicago office. They said it works, but again, I cannot confirm or deny. But you can try. Hi, George. Can you talk about relevant news about the 3 and 10-year bar on reentry? Good question. However, there is not much news for those of you guys who are in the United States. That news decision that was recently passed within the case that was filed concerns a very small group of people. It's a decision that says that 3 and 10-year bars are continued to run in the United States if after you receive this 3 or 10-year bar, you enter the United States legally, okay? Because if you enter the United States illegally, you're also going to be subject to permanent bar. So the decision that was recent about Cyprus was litigated because it's been discussed by USCIS previously that in those specific circumstances where a person, let's say, overstayed their visa, right? Started accumulating unlawful presence, left the United States, and before their bar's 3-year bar, you receive, if you overstayed and accumulated 180 days of unlawful presence, and if 360 or a year, you receive a 10-year bar. So if you enter the United States with a visa, within those times, 3 10-year bar, then you can argue the 3 and 10-year bar continued to run while you were in the United States. So for majority of people here, this decision is unfortunately useless. But it would be nice if they completely eliminated them. Yeah. Thank you, Victor. Hi, Wilson. Hi, McCrane. How long the process of work permit takes to get it for asylum? It depends. If this is your first asylum-based work permit, you're likely to receive it very quickly, within like 60 days of filing. And if it's not your first one, if it's a renewal, it's probably going to take 7 to 8 months currently. Yeah, long time. Very long time. Hi. Kiber Hussan. My dad filed 1130 for me. He is a permanent resident and I'm unmarried son. My case went to California. Now I have to wait 5 years. And right now I'm on F1 visa. Can I expedite it? When we file a case, a petition for alien relative, you need to take into consideration 2 periods of time. One period of time is called processing time. It's just the time that USCIS takes to process your paperwork, to take a look at it, okay? And that time can be expedited sometimes. But when we're talking about family preference categories, and everyone who is not an immediate relative is in family preference category, like you, for example, if you're an adult son of a permanent resident who is unmarried. There is also a priority date relevance here, and time in line to get your priority date to be current. That time cannot be expedited. It's not possible, at least currently. Under some proposals that we heard within the past couple of years, it would be possible to expedite this time for a fee, but currently it's not available, this procedure. So unfortunately, a person will have to wait for their priority date to be current. That's what's going on. Hi, Mark. Hi. During the pandemic, if someone had green card and got stuck overseas and could not return to USA for over 1 year, any way to challenge immigration decision? Well, it depends on what immigration decision you received. Did you try to file a return for returning resident visa? And what happened? Because that would be the usual route. Or did you just try to enter the United States and CBP decided to put you in removal proceedings? I'd say speak with an attorney, okay, and see what was happening, because that would be your best bet here. All these questions, answers, guys, are not real consultations. I'm just giving you ideas, all right? This is very important to know this because usually it takes me about 20, 30 minutes first to receive background information from you by asking you relevant questions before I can make my conclusion. And sometimes that's even not enough. And we have to talk longer about your potential eligibility or potential solutions. Hi, Akash. When affirmative asylum case interview will happen, which was filed since 2016, is there any chance to call for an interview for 2016 pending asylum cases? Let me grab my crystal ball. It's a joke. Nobody knows when you're going to be called for the interview. Nobody. I've met sometimes people who go to certain lawyers who say to them that they know for sure when somebody will be called. That's just not true. Nobody knows when you're going to be called for the interview. I have cases that were filed in 2016 and are still pending, and cases that were filed in 2016 and were already called last year. I have cases that were filed in early 2017 and were called last year. And this year, person already is qualified for a green card, okay? So it's hard for me to tell you. Just judging by the timeline and updates, and actually my previous video, I believe, was about the backlog with a lot of stats in it as to how many cases are pending and how slowly they're moving. I would say in another year to two, you should be called for the interview, okay? But here is another interesting news. You know, a new caravan of migrants is coming to the United States, counted at 15,000. I guarantee you that most of these people will be adding to the asylum backlog. Asylum backlog has been growing by hundreds of thousands of cases, above hundreds of thousands of cases during the pandemic, and before the pandemic in 200,000 of cases. That's how many cases were filed for asylum each year in the United States. So imagine such crazy numbers, right? Knowing that only 30 to 40% of all cases are being called for the interviews from the backlog. However, the good news that about 125, I believe, officers, 250 officers are going to be hired with intention to address only old cases. Even that, if they're facing, you know, hundreds of thousands of cases and there are only 150 of them, I mean, will they be able to, how fast they will be able to go through all those cases? I estimate it to be like 2.5, 3 years about. So here we go. This is your best prediction. You need some math there. And of course, I've never worked for the asylum office, so I don't know how fast they can, you know, go through the case. Well, I know that I think they said that they aim to issue about 70% decisions within the 2 weeks after the interview. That gives you an idea of how fast they have to process the case to the conclusion, okay? Hi, Agidi. I need to file for prosecutorial discretion to immigration judge or ICE. How long can the process take for the case to get dismissed by judge after filing PD if I already have a pending adjustment of status with USCIS? I do not know why you have a pending adjustment of status with USCIS. I guess it was a mistake when you guys filed, because usually, or maybe you could qualify for it. In certain cases, you can still file with USCIS even though you are in immigration court. Prosecutorial discretion request is being filed with OPLA. OPLA. office of, what is it? Something counsel. This is like a prosecutor or a lawyer for the government that represents government and immigration court. If they agree to dismiss your case after the review, provided there is no fraud, remember that just because you can adjust, it doesn't mean that they will not suspect fraud, especially if the case is based on marriage. It's extremely important to know that. So you have to produce, in my mind, compelling evidence and strong arguments that your case is a real marriage case, right? Especially if I-130 interview has not happened yet. So if they agree to dismiss your case without prejudice, usually, then a motion before the judge is going to be filed to dismiss the case. How long that is going to take depends on the judge. If the judge works fast, within 30 days, you're going to receive a decision. If the judge is overwhelmed with cases, then you will have to wait longer, okay? Because judges, there are not enough judges, immigration judges in the United States, and everybody wants their case to be a priority. You know, they usually work very fast, and I've noticed especially new judges are very organized. They're really trying to push those cases out and make good decisions, meaning thorough decisions, take all the evidence into consideration. So, you know, it may take some time. I would aim at about 60 days, okay? It also depends if the prosecutor is going to get back to you fast or not. All right. Hi, Mari. I'm an American citizen. I've been together for years with my partner. We finally decided we want to get married. What do I need to get him started and getting him legal here? Been together with my partner for years. Well, if your partner's been in the United States, it depends. His initial entry to the United States and previous immigration and criminal potential history will determine whether or not he can adjust status, your partner can adjust status, right? So if the partner is outside of the United States, then it will be what's called consular process. So the process may be adjustment of status or consular process, depending on where the person is and if they're eligible for adjustment of status. If not, maybe the partner entered without inspection. Then you will have to look into I-601A waiver. But regardless, the process always is going to start with legal marriage. You guys have to be legally married. You have to make sure you're not married to someone else, which is very important. That if you were previously married, you're for sure divorced. Your divorce was finalized. It's very, very important. And then you legally marry your partner, and then you start the process of sponsorship. If the partner is in the United States and can adjust, the entire package is going to be sent together. If the partner is overseas, then you'll have to do what's called I-130, Alien Relative Petition first, then go through the NVC, National Visa Center process. Then your partner is going to go for an interview in their consulate, and upon successful interview, they will be issued an immigrant visa, and they'll be able to enter the United States, and immediately they become a green card holder. That's how it works. They can be conditional green card holder first, and then they will have to remove condition after 2 years of successful marriage. Hopefully, in a nutshell, I described the process to you. Now, guys, if you have additional questions, if you would like to have a personal consultation with me, you know how to find me. You can book it online. You can book it by calling our office, 917-885-2261. I provide free information on my website, www.shautsova.com. It's right here. And on my YouTube channel, on my Facebook, we always share with you the most up-to-date and interesting facts about immigration law and certain tips. Thank you very much for watching and joining. It was a pleasure. Thank you, all of you, for nice congratulations for my personal event that I celebrated recently. And I wish to see you soon. Don't forget to like and share this video. And I hope to see you very soon.